what I'd like to try and do today is focus on privacy online and some of the issues, some of the controversial issues that many of us are familiar with, you may or may not be familiar with. There's a lot that I'm going to just assume in order to get through a very brief overview of the theory of privacy as contextual integrity that's presented in the book, the cover of which you saw a few minutes ago, and I believe is a subject for our discussion. And these are some of the controversies that many of us are familiar with, that we've confronted, that we've read about in the newspapers. And in the book, I don't only talk about privacy issues that emerge in the online environment, but just generally privacy, but mainly privacy as it's arisen as a result of the development of science and technology. And my own area of specialization happens to be information technology and computers and digital media. There are many other kinds of privacy issues that emerge, as we know, in relating to genetic information and other forms. But this is the one that mostly provokes this particular theory. And in the book, I try and create some kind of an order by categorizing these different the types of privacy controversies, some emerging from generally tracking and monitoring, and as you see in particular some of the online tracking and monitoring, and in some of the works where I apply some of these ideas and where I've been thinking for quite some time. For example, I've been concerned about the web searches that you do when you use, say, Google or any other search engine, and what happens about those web search logs. And as there's a whole family of technologies, database technologies, where this information is aggregated and it's analyzed, and we've all heard about data mining and profiling and on OBA, online behavioral advertising, and these have all been controversial. And then the third large category is the capacity of information technologies to distribute or disseminate information. And here I'm thinking about the experiences we've had, many experiences like having to do with social networks, blogs, the Facebook debacle, and but also things like Street View and the gradual placement of records, many records that were available in hard copy form locally now are increasingly being placed online, and we're looking at things like public records and court records. So these are all the areas where we confront various challenges and problems. And what inevitably happens, and I'm hoping that this is going to be a familiar thing for you, is that you have the interest brawls in which the different sides, let's call them the winners and the losers, will argue against one another. They don't like the new technology or the new systems, socio-technical systems, not just the technology, but the business practices and the social structures into which the technology is embedded. They're affected in some way, and the other side says, oh no, but it's efficient, it protects my intellectual property, it spreads information, whatever the arguments are, these interest brawls that often are the lead up to some kind of policy decision. And what we as theorists want to do is not just win the argument by the interest brawls and who can buy the best politicians, but with kind of systematic to say, this is the position we support, not just because it's better for me, the consumer or the business or whoever we represent, but rather because there's a reason. And so the book is really constructed as what I call a justificatory framework, a theoretical, so that we can give systematic reasons for supporting one position or another. And contextual integrity is just, some term that I made up, which is supposed to serve as a model for privacy. And it argues that privacy is not control over information, as many theorists have argued. Privacy is not secrecy, that is to say, simply a limitation of the amount of information people have about you. But what people really want, what people really care about when they say that my privacy has been violated, is that the information about themselves, and I just call it personal information for short, has flowed inappropriately. So what people care about is that the information flows appropriately. And of course, the next question you want to ask is, what do you mean by appropriate flow? And what contextual integrity, this theory, tries to do is to try to give you an account of what appropriate flow is. So at the heart of this theory is something called an informational norm. And the idea is that information flow in society is, as a matter of fact, governed by informational norms. And these informational norms vary according to the contexts in which we operate. And an informational norm is just a rule that governs the flow of information. And it can be an implicit rule. I think many of, Lashon Hara, or whatever it is you want to, what you can and cannot say, some of these things are implicit and understood and vague, and some of them are embodied in explicit rules. So this I'm showing you, which is, you can say, an explicit rule that was created, which was developed by the Federal Trade Commission in about 2002, following the passage of the Gramm-Leach-Bliley Act, which had to do with the merging of various financial institutions in the United States, and that was passed in 1999. And this is one of the privacy rules, and I might say it's therefore, it's an embodiment of the norm, and as a matter of fact, and I'll come back to it later, it actually does manifest the structure of the norms that I have posited. Now, the theory has two components, really. There's a descriptive component, which says this is what the informational norms look like that govern the flow of information in society. And there's an evaluative or prescriptive part of the theory that also talks about why the norms are this way, and if we're going to develop new norms, this is what they should look like. So just quickly, the descriptive part, and I must just keep track of time. And this is the question, what do these informational norms, context-relative informational norms, look like? What is the structure of these norms? Now, in order to tell you about this, in order to describe this briefly, what I need to introduce into the story is the notion of context in the first place. And again, it's not, I haven't developed a theory of context, but I'm making an assumption, I'm drawing on social theories and social philosophy that posits that when people act and interact, we interact within social realms. Of course, this is a theoretical construct, so that when we're sitting in this room and I'm talking, we're in an educational context, and we're in the university, in the School of Law. When you're sitting talking with your physician about your health condition, you're in a healthcare context, and so on. So that's the starting assumption of this theory, and I want to just isolate two components of these contexts or two aspects that characterize context. One are the norms, and the other are the values or ends and purposes of context. So our behavior within a context is governed by norms, some of them, as I say, explicit, implicit. Some of them are and there's a lot of behavior in context that isn't governed. Like we don't have rules to govern, is it okay for me to scratch my forehead over here? And I don't know, maybe at your university there is a rule about what you can do, but then there's a lot of behavior that isn't. So we have the norms, and among these norms are the informational norms. And then we have values, ends, and purposes. And within the context, there's like if someone flew in from Mars to this particular gathering or this university, they may be able to observe the behavior, but until they actually know what the purpose of these contexts is, they're not going to fully understand this context. And of course, the values or the ends and the purposes could be highly contested in a society. So some of us might say, well, education is about transmitting knowledge to the next generation. It's about providing you skills. It's about making you, informing you of the traditions and the culture in which you're, so there could be numerous values, and we could have disagreements, but maybe we would all agree at least there is a set of values towards which or around which these contexts are oriented. So the norms, when we try and identify the norms, what it is that people are expecting when they're expecting information to flow in a certain way, what's relevant to them is who the information is about, what capacity is this person acting in. So if you're a student in a school or a university, that you could talk about this is about the student. Who's the sender of the information? Who's the recipient of the information? And often the sender is the same as the subject, but need not be. So when I was filling out my tax forms, I hired an accountant. I provided the information to the accountant, then the accountant sent the information to the IRS. Then we have another parameter, which is information type. Now, a lot of theories are grounded in the idea that there are only two types of information: public information and private information. Private information, we have all the rules that govern private information, and the public information, well, anything goes. So the theories are built upon this notion of a dichotomy. That's not what contextual integrity does. What we want to do is find the articulated attributes which affect what the rules are going to say. And it could be, you could extract these attributes by, take the IRS back to the tax form, name, fields, address, children, social security number, earnings, etc., etc. And those are all the attributes that you're transmitting to the IRS. And then you have something called a transmission principle, which is not so intuitive. But I mean, actually it is intuitive, I think. But often it's not recognized that this is a factor in these rules. The transmission principle, think of it as the constraint according to which that governs the flow. So often we'll say things like, you can put a surveillance camera in this building, but you need to tell people about the presence of a surveillance camera. Now, when you say that, what you're saying is we have to provide notice. That is a transmission principle. That information of the image can flow, but you have to provide notice. And you may want to go further, and you may want to say you want to give someone control over whether they provide information or not. So the notice and control are two very widely used transmission principles in what we see in law and policy at the moment. But sometimes we do compel information from people. Sometimes when you're talking to your physician, we expect the transmission principle to be one of confidentiality, or I would like to say fiduciary, which is to say you don't expect your physician to transmit the information beyond. So, and there are lots. So when you're sitting, around a coffee table with some friends, you're talking about your problems with your kids, or no matter what. There's this understanding of reciprocity. You tell, your friend tells you, and so forth, often confidentiality. But when you're sitting in your physician's office talking about your sore foot, you're not expecting the physician to then talk about his or her sore foot, or whatever. You're not expecting to hear about the physical condition of the physician. So that's what the norms look like. And now when we come back to the Graham-Leach-Bliley rule, you can see how well, I would argue, this posited structure of the informational norm actually maps onto, and actually with various colleagues, we've looked at some of the HIPAA privacy rules, and we see similar kinds of structure given in the HIPAA privacy rules. And actually, we argue that if you don't provide these parameters, you're going to get into trouble with your rule, because people want you to specify all of these things: the sender, the recipient, the subject, the attribute, and the transmission principle. And if you do that, you're in good standing. Now, there's a problem with this theory, and that is, if you say that privacy is contextual integrity, and contextual integrity says information must flow according to entrenched norms, then you have a very conservative theory, because it says everything has to be the way it was. And so the evaluative portion of the theory confronts this question. The world is changing. We have new technologies. Many times these new flows of information are highly beneficial to us, and sometimes we don't even think of them as privacy issues. We just welcome these technologies into our lives. If you have better health monitoring that can trigger an alarm when your heartbeat goes below a certain point or something, and the nurse comes running into the hospital room, that's a good thing, even though it's somehow disruptive of the entrenched flows of information before the introduction of this technology. And so we need to be able to be open to the possibilities that these challenges are actually, we can allow them to replace some of the entrenched norms. Society moves forward. We revise our norms, according to these challenges. But what should push change? And this is, often I'll have arguments. People will say things about Facebook or whatever. They'll say, you've just got to go with the new technologies and accept that, the new generations, they don't care about things, blah, blah, whatever it is. And I mean, my argument is I welcome change, and change can be very good. But I'm not going to accept the fact that whatever Mark Zuckerberg's latest whim is in regard to privacy and the design that he just happens to put into that technology gets it right. There has to be some way of evaluating these changes in respect to the values, the political and ethical values of the societies in which we live. And so that's what we try to do in the evaluative portion of this theory of contextual integrity. Now, this part is quite complex, and I'm just going to put the language out there and not really explain very much. There are really two steps of the evaluative portion of this theory. One is we need to do like a comparative analysis between the world, if you will, before the introduction of these disruptions of informational flows, and the world after these disruptions. The world before Google Maps Street View and the world after Google Maps Street View. So we can understand how these different flows affect us and have a way to evaluate them. So the first step of the assessment, and here I can say there's a huge literature and a fantastic privacy literature that really tries to identify why certain flows of information can be problematic. They can challenge autonomy. They can be problematic for democracy. They can make business more efficient, etc. So we need this analysis that looks at the new flows and understand what the impacts of the new flows in terms of familiar values, in terms of familiar costs and benefits. So that's a lot of work that's been done, and it's all out there. Now, contextual integrity wants to take you to one more step, because often what we find in these analyses, take something like digital rights management or TPMs. They may say, look, this is the way to protect intellectual property. And the folks on the other side are saying, yes, but it's not appropriate that what you read and the music you listen to is monitored, etc. And so we get into this conflict, and we say, how do we resolve this conflict? Now, what we do, the second round of analysis, if you will, is to understand how the values within the contexts are served. So if you take something like healthcare, you might say that there are good reasons for a society to want to be able to have this healthcare information passed from one party to another. And there are good reasons why someone who has certain diseases, especially ones that might be stigmatized, might want to withhold that information because they can be harmed, embarrassed, discriminated against, and so on. So you have a kind of conflict of interest that you arrive at. Now, what contextual integrity wants us to do in this analysis is say, whatever the policy is that we're going to adopt, how does it affect the achievement of the purposes of that context? The internal values of that context have to factor and sometimes can break the tie, so that you might say, you know, if you have infectious or contagious diseases that are highly stigmatized and you're not going to guarantee that this information doesn't flow beyond, say, the physician's office, and these phenomena have actually been tracked, people will not actually seek medical care. They'll go from one doctor to the other. They won't tell the full truth. And then this is problematic for that person's health and also arguably for the health of society. So you might say that the rules, the information flow rules, must be also responsive to the values, the internal values of the context in which the rules govern. So we have our decision heuristic. If we're thinking about policy and design, the steps that I'm proposing is we need to establish a context, we need to fix the parameters, we need to do this analysis of, let's think through what happens with this policy or that policy, and then we evaluate in terms of the values, ends, and purposes, both generally and also within the context. And what I propose is we think through system design, policy, and law in these terms. And I just want to end now by coming full circle to the online, some of the challenges that we confront online. Because as you can see from this theory, there are ways in which this theory can be helpful and is helpful. In particular, it really kind of diagnoses what the changes are before and after the introduction of a certain technology in ways that other approaches simply do not. So when there was a big debate about Google Maps Street View, those who defended it said, there's no change, you know, you're walking in a public street. This photographs you in a public street, no change. But if you do a fine-grained analysis on the flows of information after Street View, you can see what a radical change has been imposed by the introduction of the system. So that's kind of step one. And then step two is to say, is that a good thing or not? In the online environment, we have, it's just clear, these novel flows have been, and this is like the red flag, right? We flag a change, are enabled by the architecture and mechanism of the online environment. Another challenge is we have new forms of information that we're clearly not going to have entrenched norms. You know, we're not going to have norms about IP addresses before we had IP addresses. So we need to figure out what those rules should be. And what I'd like to suggest, and I'm not going to discuss this, I'm just going to have this be a point of thought, that I don't think we can have a theory of privacy online, because the internet and the web is a mediation. It's not a single context. We can't say privacy for the online world, because it mediates multiple different contexts. So if we take that as the premise, think about these two kinds of scenarios that I want to have you think about. One is when the activity it mediates is very similar to one that we're used to. So when you do online banking, or when you perhaps are, and probably increasingly we're engaging with, say, healthcare organizations, and at least in the US, just, you know, we're really pushing in that direction via mediating it via the web or the internet. Are we saying, I wonder what rules govern online activity? I don't think so. I think we're saying this is banking, and we want to make the same assumptions about the information that's flowing between yourself and the bank or your financial institution. Not the rules of online engagement are now carried over into the banking environment. So that's one, I call it a proposition, because, you know, I haven't proven it yet. Second is this, and these are really deep and interesting questions and even more complicated. It's sometimes the context itself is contested. If you can't even prove what the context is, then the starting positions are not that great. So when we've had arguments, because we've done work, and some of you may know about TrackMeNot, which is a tool to help individuals. It helps individuals protect the privacy of their web searches. Michael Zimmer, who was a student and who looked at, say, who did a study of Google's different services, what we wanted to do is to position web search as an educational activity, to make it, to explain why web search was like doing research, going to the library. We wanted to have that be the governing context of web search, because once you can argue that point, then many of the norms will follow from that. And I feel like we've been doing some work on online behavioral advertising, which I'd be happy to discuss if anybody here is interested. And I personally have not been working on social networks, but I would argue that social networks are there's a lot of discussion that's occurring around social networks, and part of that is to try and contest what kind of contexts are being mediated by social networks. And I would say, depending on the answer to those, we are going to see different norms establish themselves in that environment. Thank you very much.
It is a great honor and pleasure for me to discuss Helen Nissenbaum's splendid new book, Privacy in Context. This is the book. This book is a genuine gem in the privacy literature as well as in the law and technology literature. It is well written, founded, and above all, deeply intriguing and thought-provoking. Helen managed to do what many have tried over the past decade but failed, and that is to take the privacy discourse forward, and not only one step but several steps at once. I would even dare say that this book signals the beginning of the end of old privacy paradigms and projects a new paradigm. No one could perform such a discursive advance other than Helen. As a philosopher of technology, Helen has exposed in previous work the social and cultural meaning embedded in seemingly neutral technologies. She has advocated public design of technologies, drawing our collective attention that we can and should, as a society, demand that technologies reflect our moral and social values. Privacy in Context is a brilliant culmination of philosophy of technology, law, and surveillance studies. It is therefore worthy of the utmost honor we in academia can accord a fine piece of scholarship, and that is debate it, question it, and challenge its theory, and perhaps, as I will try and do, disagree with some elements of the theory. The book is composed of several arguments which join together. I will outline the main arguments, at least as I read them, and comment on the methodology for searching for a good privacy theory, on Helen's treatment of the privacy as control theory, and will discuss a few shortcomings, in my view, of your proposed theory, especially on the normative as opposed to the descriptive level. So the first step in Helen's argument is that technology has a social meaning and embedded values. I concur, so I can switch to the second argument, which is about the methodology of privacy theories. Helen describes various efforts undertaken in the literature. Some, Warren and Brandeis and others, provided definitions which perhaps served as important political, social and legal vehicles to promote privacy, but they lack the justificatory power. Others have provided explanations, either bottom-up explanations, such as describing situations of privacy, Ruth Gavison's theory, for example, or more recently Daniel Solov's privacy taxonomy. Another strand in the privacy literature is the justificational one. Helen opts mostly for the descriptive option, although she strives to add the normative component, as we've heard. I will return to the specific privacy in context theory later on. A third step in Helen's argument is ruling out current dominant theories. She describes the two main theories at stake: privacy as control and privacy as access. Both are described by Helen as descriptive rather than normative, and she subsumes both of them within her suggestion of contextual integrity. Helen does not rule out either, but it is pretty clear that she prefers the privacy as access rather than the privacy as control theory, at least in my reading. I agree that the access theory is descriptive, but disagree as to the control theory. The privacy as control theory meets two crucial conditions of a good theory: fit and justification, to borrow from one of Helen's colleagues from across the street, Professor Dworkin. It fits privacy as control. It fits current social and legal practices and can explain many of them in an intuitive, clear, and convincing way. This is probably more so in Europe than in the US. It is also justified, not only descriptively but normatively, as it encapsulates the meaning of privacy as an end rather than a means alone. Many wrote and explained how privacy has an instrumental goal, in that it promotes equality, facilitates free speech, democracy, etc. Many more wrote and explained how privacy promotes autonomy, self-fulfillment, how it relates to fundamental notions of human dignity, how it meets psychological needs, etc. I need not rehearse all of these theories over here. Privacy as control is a catchphrase for all of these. Surely, privacy as control has its problems. Unfortunately, there was those who equated control with property, a wrong move, and then argued that privacy as control serves to commodify us, us human beings. However, this equation is wrong and unnecessary. Another problem with the privacy as control, this is not Helen's theory, privacy as control, is that it still needs to be fleshed out and translated into concrete legal rules. And this is not always an easy task. Notice, choice, consent are the usual tools, and each have their problems. Enforcement in a global digital environment is also a high barrier that we need to pass. However, this is a challenge, not a knockout. I'm afraid that Helen rules out privacy as control too soon. In fact, my reading of the book, Helen's book, indicated that she equates control with withholding information. If so, I might be wrong about this reading, but this was my reading. If so, this is too narrow a conception of control. Control is not to withhold information, but rather to be in charge, to make autonomous decisions as to if, when, how, to whom, under which conditions, etc., will the data subject, the person at stake, will the data subject transfer information to another person, another corporation, the state, etc. This can extend to cover subsequent transfers of data flows, for example, by the limited purpose principle, which instructs that data collected for purpose A can serve only for purpose A and not for purpose B. This principle is part of Israeli law, as well as Israeli privacy law, data protection law, as well as the European data protection regime. The last and most important step in Helen's argument is the theory of contextual integrity, which Helen summarized earlier. This is a social theory embedded in social contexts, or to use Pierre Bourdieu's terms, a field. It is our task to identify the context or contexts at stake, study their internal mechanisms, and figure out their informational norms, or what Helen terms transmission principles, which she discussed earlier. This enables us to evaluate technological, social, political, or legal changes, and flag out, in Helen's words, the way in which, quote, a system or practice defies entrenched norms, unquote. This is the descriptive part. Helen then proceeds to the normative element. She instructs us that once we found a prima facie violation of a transmission principle in a specific context, we should, quote, consider moral and political factors affected by the practice in question, unquote. The meaning of these moral factors should be considered, quote, in light of contextual values, ends, purposes, and goals, unquote. This is, of course, a terribly brief description in the limited time, so I apologize for this extremely condensed summary of the theory. The descriptive element is indeed a powerful device to observe and better understand excuse me, to observe and better understand what exactly bothers us with a new application, technology, or practice. However, I'm not convinced by the normative elements, and unpacking them highlights the problems of privacy in context. Firstly, as Helen admits, this is a highly conservative theory. The current situation is the baseline and is preserved unless we are assured that the change is for the best. Let's say Facebook announces a new privacy policy which improves users' control over their information. Helen also allows other changes which do not necessarily improve privacy if these changes satisfy the moral and political factors mentioned earlier. This approach assumes the status quo ante and takes it as a given. Thus, it ignores the possibility that the current status might be bad enough, for example, due to unequal power relationships. This is the case when the government seeks data from the citizens, when a large firm offers us only a standard form contract, take it or leave it sort of contract, or when the employer monitors every move we, the employees, make and every click we click. The introduction of a new policy can be evaluated according to the contextual integrity framework, but it accepts the current situation. A theory of privacy, I would argue, should be able to assist us in evaluating current practices, not only changes. This was a critique of the conservative feature of the theory regarding the present and near future. I would argue that the conservatism limits the power of the theory as also not only regarding the immediate future, but also some more distant future. Together with Professor Niva Chituv, who's sitting here, I'm involved in an EU-funded project called Practice, which attempts to evaluate the privacy implications of future technologies, not only information technologies, but many others that will loom in the horizon within the span of 20 to 30 years. Let's assume this is possible. I'm skeptical about our methodology, but let's assume this is possible. According to Helen's theory, we will be able to point to the delta, the change, and identify the changes as compared to the current situation. But we need to know now, or pretty soon, what will be the privacy implications of future technologies so that we can deal with them ex ante, maybe legally, and perhaps through the design of the future technology before it appears and becomes pervasive. Secondly, there are some gaps in the normative aspect of Helen's theory. What exactly are the transmission principles of a specific context? Helen provides examples, and we saw an example on the board, on the screen, and she points to several such principles in some context. But as I read and reread them, I could not but ask, well, perhaps this is a transmission principle in a specific context, but is it a good one? Why is it such that we have such a principle of reciprocity in the examples you gave, etc., or not having reciprocity? What is the justification for principle A and its superiority over alternative principles which could have been there? The justification seems to lie elsewhere, and I'm not quite sure where exactly. Thirdly, the normative element deals with a conflict in an interesting way. We are used to say, at least in the Israeli context, but in many other places, that privacy often conflicts with other rights and interests, such as free speech rights or national security and law enforcement interests. In Europe and in Israel, we conduct some sort of a definitional balance, mediated by principles such as proportionality. This is viewed as an external conflict and dealt with on the external level. A right conflicts with an interest or with another right. In the US, the same definitional result is achieved through definitions and their interpretation, mostly of the Fourth Amendment and various derivatives of it. In my view, the American way of defining categories is a disguised form of balancing. Helen suggests that we need not engage in such balancing at all, on the definitional level. Rather, she internalizes all the rival interests into the specific context. This is part of the element of the, quote, moral and political factors mentioned earlier. Thereafter, we might find ourselves engaging in an ad hoc balancing on a case-by-case basis. I'm afraid that the theory of contextual integrity of privacy misses a lot in the process of internalizing the conflicts. The result might be the same under either method, the external balancing, as we do in Israel often, or the internal method that Helen suggests. But the road does matter in many cases. When privacy conflicts with another interest and loses, we all lose. We pay a price. We should be able to say in a particular context that, for example, national security interests are more important than privacy, and we have no choice but to pay the price in terms of privacy. We should acknowledge that we are paying the price. This will enable us to reevaluate the policy if security circumstances improve. The British recently have started to realize that they have gone too far. Nick Clegg, that's the new guy, announced the new second guy. Nick Clegg announced plans to scrap all biometric databases to minimize DNA databases in the UK, and they have a lot of them. Under the book's theory, Helen's theory, the price we are paying in such conflicts, I'm afraid, might be lost within the internalization process. To conclude, this book is a true achievement in that it searches for a clearer theory of privacy, a much-needed task. Theory is surprisingly scarce in the privacy literature, and the good theory is much needed. Helen thus engages in a brave project. She exposes the importance of methodology in the theoretical search and offers ingenious observations. Her suggestion of contextual integrity of privacy has a great advantage as a descriptive tool, but on the normative element level, I beg to differ. But I'm truly thankful for this genuine original contribution to the privacy jurisprudence. Thank you.
The summary of what I want to say is that I think that privacy is taken too far. The header is there's a moral panic about privacy, and I have a personal panic about this being a moral panic. And I'm going to try to use the few minutes that I was allotted to make the argument on the other side, in some ways completely agreeing with Helen's argument that it's all contextual, that it's not absolute, but maybe even contextualizing it more than Helen did, and certainly more than Michael has patience for, because we've had this discussion in the past. Let me begin with 3 or 4 short vignettes, just short stories, and then suggest 5 or 6 questions to be asked. And let me warn you in advance that none of this pertains directly to legislation. I'm not going to say anything about legislation because I don't know much about legislation. I'm not going to say much about legislation because my bottom line is I think there ought to be less legislation. That we are, in many ways, as I said, victims of a tsunami of moral panic that arrived at our shores. But as I said, let me begin with 3 short stories. I'm not sure how true they are. So these might be made up. Doesn't matter if they're made up. The point is there even if they're not true stories. The first story is a story I was told about the background in legislating the, what's it called? חוק הגנת הפרטיות, התשמ"ד. What's it called in English? The Privacy Protection Act here in Israel. And, I'm told that it passed with the support of religious party votes because they were told a story about the fact that the voter registrar was leaked. This is 1984, even earlier. And, this is the bad part, was used for the marketing of tampons to 12-year-old girls. End of story. True or not, I don't know. Left up to you to ask whether this is really something to become indignant about. I mean, what's the context of privacy violation in this respect? Second short vignette. I was a student in the US in the late 1970s. Prior to that, I served in the Israeli military. I did my mandatory duties, and then I served in what's called Keva for a while. And my wife and I went to the States to study, and we frequented a ice cream chain store called Friendly's. Some of you might know of it. Some of you might have also filled out their little postcards that said, give us your name and birth date, and we'll invite you to free ice cream. I think they had really nice banana splits on your birthday. And then the Khomeini revolution came to Iran and caught the US unprepared. Unprepared in the sense that it had abandoned all registration of conscriptable or draftable young people, and the Pentagon scrambled to get the lists of people who could be drafted in the case that they would be needed. This is 1979, and the first place they turned to was Friendly's ice creams chain to buy their list of people who signed up and gave birth dates. Now, I think the law of limitations gives me, I can now disclose that I actually signed up under a few names and a few birth dates. And so I started getting draft notices. And again, the question is, should I have been indignant? And should I have called in the Marines to protect my privacy? Or should I have just laughed it off? The context, I think, is important here. Last story I know is true. This law that we mentioned, the 1984 Israeli law about data protection and privacy, and it's colloquially called the privacy law, I think. It's not officially named that way. Charges a specific Israeli government official with enforcing it, and I think it's an awful law. I think it goes much too far, and I urge you, if you haven't, to read it. I assign this law as required reading to all of my students because it is one of those interesting laws that is not known well enough and actually requires managers to assume responsibility far beyond what most managers know or intend to act. It's an incredibly stringent law. The story is that this law was enforced and not enforced off and on over the years by changing officials in very widely varying degrees of stringency. In much the same way that an even more awful law, the computer law in Israel, that law that makes anyone who makes a computerized list of people and says something about them and doesn't register it with the government, criminalizes them. So that's a stupid law, and that's a stupid law, and they're both defended by legal authorities with a Latin term I learned in law school. You can't say I didn't learn anything. De minimis, right? Don't worry about it. They didn't really mean it, and we don't really mean to enforce it, and so don't worry about it, is what I'm told it means. So it's in law, but we didn't mean it. So why should it be in law in the first place? Well, we did have one especially active registrar of data, data collections, data repositories, who decided to step in and require the credit companies to cease and desist from their really evil practice of providing people coupons, giving them discounts on pizzas in pizza parlors next to where they live. And the credit companies had to cease and desist because they were doing something that was obviously outrageous. Something that the credit companies wanted to do, the pizza companies wanted to do, and pizza consumers wanted to do. The only people who didn't like it were the indignant, moral panicking spokespeople of privacy. I'd like to pull these three vignettes together and ask, are we not going much too far? It's my privacy regarding my date of birth, your privacy regarding where you live, their privacy regarding which brand of pizza they like to buy. I can't get too excited about it. And I can't get too excited about it because of the following 6 or 7 questions that I'd like to pose more as questions. And pardon? Well, it's growing. Helen, you mentioned that these new technologies are a disruption. You titled them as a disruption. I think all of life is a disruption. Anything coming at us from the future is a disruption as compared to the past. And so what we need to ask is about the past and about the future. About the future, I'd like to ask, I think we should all ask a question that is often asked and I think very important to answer honestly. And that is privacy at all possible? And some very serious people, not myself, but some titans of the industry in computers, suggest that this is all futile because there is no privacy, there's going to be less, and get over it with. It's a direct quote of Scott McNeely, the president of Sun. And I don't know if he's right. He might not be wrong. It might be true, and therefore there is more cause for moral panic. But moral panic without an opportunity to fix anything is a different kind of moral panic. Certainly not one that I'd like throw into the hands of the legislature. Question 1, is privacy at all possible? Question 2, do people really want it? And I'd like to suggest that we have a preponderance of empirical evidence that generally people want privacy a whole lot less than the indignant, politically correct spokespersons in favor of privacy would like them to want. And whenever people are given the opportunity to opt between privacy and 2 cents, they prefer the 2 cents. And if that's the case, if that's the pricing people, given their own free will, place on privacy, then maybe those who speak for privacy are being a little bit too paternalistic. Maybe this whole notion of privacy is someone imposing their norms on a public that isn't interested in these norms. The empirical data just speak loudly to this. And Helen, you alluded to the fact that younger people are even less interested in privacy, and we have lots of empirical data regarding that. That is a particular field in which I have some information. Question 3. Since when privacy? What's the history of it? Is this something that has already existed? Is it a value that has always been cherished? Is it a basic notion that is enshrined in some basic values, or is it just a recent invention? And I'd like to suggest that under varying definitions, it's a fairly new concept. In fact, the icon of privacy, the emblem of privacy, the fig leaf, was only invented at the later stages of the Renaissance, and there too by your friends, the conservatives, and there too, I think, with a net negative result, to art at least. And it's no wonder that the fig leaf has been given a pejorative meaning. It's not something that we... So I'd like to argue that, yes, there is a mention of privacy in the Mishnah, lo petach mul petach. Yes, there are some mentions of privacy earlier, but I think we should dispel the notion that privacy is some eternal value. It's not. It's a whole lot less important than right to life, right to property, right to freedom of speech. It's a minor right. if we're going to, and one that is, I will agree, contextual, if I understood the notion of contextuality correctly. Question number 4 is, if we tighten the screws of privacy legislation, who stands to benefit? And I'd like to argue that privacy already is mostly a privilege of the privileged. And the more we tighten the screws of privacy, the more we discriminate against the poor and the weak. Because privacy is something that rich people have. And the more privacy we get, the more gated communities we get, the more the constituency of Clegg and not the constituency of labor benefit. Just an argument, I can't prove it, it's a gut feeling. Question, where are we? 5. I'd like to argue that we're all talking about different things, a definition, and then this is an easy argument to make. The definition of privacy is so diffuse that privacy for one person is something else for another person. There used to be extremely different conceptions of privacy in European law as contrasted with American law. Those who spoke about privacy, who referred to privacy from corporate intervention or spying, were different from those who spoke about privacy from government intervention. 9/11 changed things around, but it is still the case that for some people, talking about their sexual behavior is an invasion of privacy, but talking about their salary is something that can be done. And for other people, talking about their salary is the big no-no. That's the big secret. Please don't ask me how much I'm making, but I'll tell you about my sexual privacy really easily. In fact, we'll be proud of it. If there are so big differences in the conception of what privacy is, shouldn't we be a little bit more careful about legislating it? I'd like to ask one more question about the definition of privacy, and it goes directly to the contextuality issue, and that is, does privacy even belong in the realms of law, or is it a matter of politeness? I'm not negating privacy. I'm not negating shyness. I'm not negating bashfulness. I'm not negating some needs that some people have to keep secrecy. I'm certainly not taking away the right to keep things secret. But I'm asking, should we have laws about this? Is this something I'd like to trust members of Knesset to dabble with? I'm not sure. Or maybe less than not sure. And last question. And I think, actually, Michael, I want to thank you for asking. At the end of your talk, you raised the opposite side of the same question. You indicated that Niv, who should have been speaking here instead of me, he wrote a book about this. I'm not an expert on this. And you are studying the future of privacy-threatening inventions or innovations. Or the implications. And you asked whether it is even possible to predict these innovations. If it's not possible to predict these innovations, you really want to legislate about them? I'd like to turn a question you asked around. You asked, you urged us to say, if we give away some privacy, let's be explicit about paying that price and understanding what it is we're getting in return. That's almost a direct quote of what you said. And I'd like to phrase that same question, but in reverse. If we insist on privacy, if we tighten the screws of privacy, if we make the walls higher and we close all the opportunities to know about each other, what are the prices we pay? Will we not, with more privacy than we already have, backed by the police, not have less solidarity? Isn't privacy a cloak behind which sometimes really awful violence, domestic violence, personal violence, tax evasion, other sorts of ugly stuff hides? Isn't privacy often somewhere that villains use to hide? Helen, you mentioned twice or three times during your talk the patient-physician context as one that you want privacy in. I think health is a great context in which we should understand that privacy is a big threat. I want people who are sick with contagious diseases to be forced to disclose it. I want people to be forced to allow their kids, or actually bring their kids in for inoculations, vaccinations. I like a lot of bad stuff hiding behind privacy be taken away by lowering the barriers rather than making them higher. Most importantly, I'd like to suggest people read some of the communitarian literature, especially Amitai Etzioni's stuff, on the use of privacy to reduce compassion. In a society where we have too much privacy, we have too little society, too little social responsibility. Helen, you mentioned Mark Zuckerberg's whims, and you suggested a Gedanken experiment. Said, what would happen if he did such and such? Well, what would happen if Facebook and generally technologies of communication were torn down, harnessed in, made to not allow things like buddy lists and social networks and so forth? Will this really be a better world? No one mentioned the security cameras in the UK that are not being taken down. I'm not even sure that the DNA databases will eventually be taken down. I can certainly acknowledge that many of these privacy protecting acts, whether they're legislative or normative, are important. But if I can make a modest contribution, I suggest that we study the history of moral panics and see if we're not reacting to the innovations of technology a little bit too indignantly, reading what people really want, reading what people really value, and reading where history really was. Thank you.
I wanted to talk about the last step this paper or this book should make to our world, the world of law. Helen is a philosopher, and the book actually is one of theory, and the question is to what extent can we apply it to practice. Now, I too join into the great compliments regarding this work, and I will start with Helen's last slide, pointing to the issue of social networks such as Facebook. And many people around the world, legal scholars and policymakers, are struggling in figuring out how do we go about solving this conundrum. We find ourselves unable to solve these policy privacy issues with the tools we have. And my sense is that the theory of contextual integrity opens up a door to conceptualizing the problems and to resolving them. And I hope that perhaps in the Q&A, Helen would have a chance to illuminate upon these issues. On the theoretical legal realm, my sense is that this theory deals directly with some of the greatest questions we have in privacy law today. Now, Helen mentions the public-private divide, and in the paper explains how we should resolve these issues, that the dichotomy of dealing with private versus public areas is somewhat problematic. She also explains that the reasonable test, which is applied by Justice Harlan in his concurring opinion in the Katz case, she points out that it has an objective and subjective flavor and explains how it should be mixed within her theory, another very important point. But it also applies directly to the most cutting-edge privacy scholarship we see. For instance, Daniel Sullivan and Neil Richards have been working on privacy's other path, which is the issue of privileges, and they're pointing out that the laws of privileges are not usually addressed within privacy law, and they should be brought in. But within Helen's doctrine, there's no problem. The issues of privileges, as she pointed out, are a direct section of her scholarship, so there's no reason to bring in that different path. This is a central path to your understanding of privacy. Another issue we're trying to deal with today in privacy is the third-party doctrine, right? We're trying to deal with the fact that when Jimmy Hoffa wore a wire, when Jimmy Hoffa's accomplice was wearing a wire and was Haifa was recorded by the FBI. So at that point, Haifa said whatever he said could have been used by the FBI because he trusted someone who should have been trusted. And we're seeing how this doctrine is being pushed into other contexts, and we don't really know where and how it should be stopped. And we see Oren Karen, some, I believe, problematic scholarship in the Michigan Law Review and elsewhere, pushing this concept, which comes from the Constitution and the Fourth Amendment, too far into the future. And Helen's work directly deals with this. She says, listen, the third-party doctrine exists in law, but here, let me show you how we map it in. So even though this is a philosophical piece of work, it has very clear policy implications and is very helpful. But looking at other issues, there might be some problems adding this to the policy world. And one point which I wrote to myself, and I wouldn't have much to discuss because it was touched upon both by Michael and by Shizeff, is that of consent. Now, what I see as the key problem in today's privacy discourse is the issue of consent, that people provide their information willingly. And of course, then as policymakers and legal scholars, we have to start thinking, really, did they provide it willingly? Did they think it through? Did they have a different opportunity not to provide the information? And Shizeff is laughing because he sees very quickly how the discussion goes from trying to figure out, was there real consent, to telling the individual, you couldn't have agreed to that, or something that academics and philosophers call paternalism. Now, my sense is that this theory does not help us mapping out when is this real consent, when we have to re-examine the level of consent, something Michael was talking about in the level employee-employer and other areas where we might have monopolies, and where we're telling people, you have conceded, but that is not enough. And in some contexts, paternalism is fine. Okay, we have a great deal of paternalism in this world. Go get on your motorcycle without a helmet and you'll be stopped. You could get on your bicycle without a helmet and you'll be stopped as well. But so you don't have to wear a helmet in this room. But figuring out this very difficult issue of consent, paternalism in the realm of privacy is something this theory, I believe, does not help us. Now, looking at the meta discussion of policy, we have another problem as well. So when Professor Judge Posner looks at theories and alternative theories, he said you can't just look at the theory and point out difficulties in it. You have to check the theory that you're providing and examine the costs of implementing it. And my sense is that on the policy level, implementing contextual integrity has many costs. Now, one cost will be, as I see it, moving many of the decisions from ex ante rulings by regulators to ex post rulings by judges. The judges will make the ruling about the norms of flow, of appropriateness, what is the context, very difficult calls. Calls that will be led to judges that are not perhaps skilled in levels of technology, and maybe also will be led to certain level regulators who are to a great degree captured and subjected to powers of lobbyists. So my fear is that the theory of contextual integrity is an excellent theory, but when brought into the world of policy, forces of economics, of cost of legal system, inability of justices and low-level ranking officials to deal with changing technologies will perhaps lead us to a worse off scenario. Now, my final point is one that I haven't totally thought through, and it's not that I haven't totally thought it through since I read the book, but since I met Helen and heard her lecture about contextual integrity for the first time, which is probably in 2002, and then again 2003, 2004, 2007. So I haven't cracked this issue yet. And this issue pertains to my main line of interest in the realm of privacy, which is data mining. Now, I have a fear that data mining can challenge contextual integrity in the following sense. The theory of contextual integrity looks at a way that information is being analyzed within a specific context and examines what we think about the way the data is used in the analysis and the proceeds of analysis, how they are used within this realm of context. Now, data mining challenges two of the processes I discussed. Data mining, correctly defined, is analysis driven by machine without the individual drawing out the specific lines of such analysis. And you just subject the data, these vast databases, into the computer, and out come clusters, the way the data is broken down, and various association rules. And later you could apply these rules to new data that you have. Now, what is very interesting about data mining, it's impossible to predict ex ante what you're going to get ex post. What terrible secrets will be revealed, or what perhaps great benefits to society will come out. Point one. Point two, context is under attack, because you might come up with the following very interesting correlation, that individuals in the realm of transportation purchase one-way tickets in cash, and individuals that in the realm of credit don't use credit cards, or only use credit cards that could be paid in advance. In the context of telecommunications, only use prepaid phones. And in the context of hotels, only use hotels that are in certain hubs. When you put all this data together, you get someone boarding a plane in Boston at 9:11 in the morning. Now, these are very different contexts. And when looking within every one of a context, we might receive a certain understanding. But when you look at a very different context, our understanding is different. Now, what do we exactly do here? Do we let the people within a specific context govern the norms in other contexts? Now, Helen could deal with this easily because, as Michael said, the last point of balancing brings in issues of politics and other social values. But when you bring in the politics and the social values from other contexts, my sense is perhaps we're destroying the theory in its entirety. So data mining perhaps attacks contextual integrity because it allows learning a great deal from one context to another, and it allows for learning information ex post, which the norms that we have ex ante do not tell us anything about. Now, I have to reread again all the papers to see if we have a good response to this, but my sense is that, at least in one way, data mining is a challenge to this theory. Thank you very much.